Team 6 to assassinate a political opponent and not be subject to prosecution for it. Sauer's answer was effectively, that's right. Unless he were impeached first, he would not be subject to prosecution. Is that your view as well?
I think a similar question.
So just tell me yes or no.
Yeah, and I want to tell you that as a judicial nominee, I don't want to prejudge any case, regardless.
Well, I'm not asking you to prejudge. I'm asking you to talk about he's got immunity unless he's impeached. That's what the court has held. And he's not impeached because he can't be impeached because he's arrested enough of the Senate to prevent his impeachment or even an impeachment proceeding. What's the remedy? It's the way we have already seen and I fear we'll see in the future. I think the Roberts Court will go down in history. That will be their legacy as having. Sorry. Thank you, Mr. Chairman. Mr. Smith, I believe that a lot of the corruption that we're seeing in the administration and the White House traces back to a single decision of the Supreme Court granting the president immunity, absolute immunity when it comes to certain core functions of the executive, a qualified immunity as to other official acts. The only area where a president would be personally liable for prosecution would be purely personal conduct, which is hard to imagine what that entails given that the president is president 24 hours a day. You were part of the president's legal team defending the president, articulating the president's position in Trump v. United States. I want to ask you about that. In the Court of Appeals, John Sauer, one of the counsel for the president, was asked by a Court of Appeals judge Penn in the D.C. Circuit whether under your theory of the case, his theory of the case, a president could order SEAL Team 6 to assassinate a political opponent and not be subject to prosecution for it. Sauer's answer was effectively, that's right. Unless he were impeached first, he would not be subject to prosecution. Is that your view as well?
I think a similar question was also asked at the oral argument at the Supreme Court a few months later. I think the Supreme Court has now set forth a test in Trump versus United States that would address that hypothetical situation, which, based on my relationship, I might add, I think is outlandish, and I see no reason to think that that hypothetical would ever be a possibility.
Well, so is it your view as well, as it was Mr. Sauer's, that yes, the president could assassinate a political opponent and not be prosecuted for it if his party won't impeach him in the Senate?
I think Trump versus United States that you mentioned, Senator, now has addressed to some extent the impeachment judgment clause, and that is set forth in the opinion. It would be something that I would be bound as precedent to apply if I was to address.
With my hypothetical, what's your answer? The president orders SEAL Team 6 to kill his political opponent, one of them, maybe several, uses the military to do it, so it's within the scope of absolute immunity. Is it your view that he is not subject to prosecution for that if the members of his party will not impeach him?
Yeah, with that hypothetical or any hypothetical that you might try to pose, Senator, I would just refer to the test that the Supreme Court has set out.
I'm asking you your view, so just tell me yes or no.
Yeah, and I want to tell you that as a judicial nominee, I don't want to prejudge any case, regardless.
Well, I'm not asking you to prejudge. I'm asking you to talk about your view and also what you argued, what you counseled the president in that case. Did you make the argument as a member of the president's legal team that, yes, he could assassinate his opponent if he used the military to do it, and if his party wouldn't impeach him, that he would be protected?
Yeah, so I can't get into any privilege conversations, as you know, due to attorney-client privilege, but I would refer you to the remarks that John Sauer had at the Court of Appeals and the Supreme Court.
Well,
this is the moment where the exchange stops being theoretical and starts becoming revealing. Notice what just happened. A direct yes or no question about the limits of presidential power is met with deflection, first to court rulings, then to privilege, then back to someone else's statements. But there's no clear denial. And in a setting like this, silence or avoidance can speak just as loudly as an answer. The senator is narrowing the question deliberately, trying to force clarity on a deeply uncomfortable implication. If there's no line here, where exactly is the line? And the refusal to draw one. That's what's keeping the pressure high.
The remarks that he made were, yes, that's correct. He would be immune. So I don't hear any disagreement with you. Do you disagree?
I would disagree with your characterization of how he responded to that question. I think he said it was outlandish, would not happen, and that there would be a process to hold someone like that accountable. And I think
the process, the question from the judge was, if he were not impeached first, is that your position? And that was Sauer's position. It sounds like that is your position as well. Let me ask you about a different part of the court's opinion, that is that the only area where he's truly liable is purely personal conduct. So let me ask you this. If a president uses their official position to enrich themselves, is he immune, or is that purely personal?
So Chief Justice Roberts asked a similar question at oral argument. I think counsel referred him to the...
I'm asking you.
Yeah, I want to refer you to the same place, the United States versus Brewster.
Don't refer me, just answer the question. In your view, if the president enriches himself through his office, is he immune, or is that purely personal conduct?
Yeah, so I think the United States versus Brewster decision said
you're not answering my question. Let me ask you a different one, see if you'll answer that. If a president took bribes to change the country's policy in the Gulf, purely personal or subject to immunity?
Brewster dealt with bribes, and in that case, the court said that a legislator could be prosecuted for bribery.
We're not talking about a legislator. We're talking about the President of the United States, who has immunity now thanks to your work in part. So let me ask you another question. If a president demanded money from a media organization in order to approve a merger, immune or purely personal conduct subject to prosecution?
Every hypothetical situation will be addressed by the test in Trump versus United States on what type of immunity would apply.
Yeah, so you're not going to answer the question. What if a president falsely arrested a sufficient number of senators such that he couldn't be impeached? Is there a remedy for that?
For each of these hypothetical situations, the Trump versus United States test would be applied.
Okay, the Trump versus United States test would be applied. So the president is using the military to arrest members of Congress to prevent his impeachment. What's the remedy?
In each of these hypothetical scenarios, Senator, the remedy is...
What's the remedy?
The court would go through the different types of presidential power that might be at issue. There's a different test for absolute versus...
He's passed the test. He's got immunity unless he's impeached. That's what the court has held. And he's not impeached because he can't be impeached, because he's arrested enough of the Senate to prevent his impeachment or even an impeachment proceeding. What's the remedy?
So, Senator, as I've said, for each hypothetical scenario you're trying to present, the court would look at the different tests that the Trump versus United States would present.
I'm just going to have to conclude here that you don't want to express your view on it, because I think it's a shocking view. I think it was a shocking view that John Sauer expressed in the Court of Appeals. I think it's a shocking view that you hold, that the president's authority is so profound that he basically is above and beyond the law, that there's no remedy for a president who would abuse his power the way we have already seen and I fear we'll see in the future. I think the Roberts Court will go down in history. That will be their legacy as having...
What you just watched is a textbook example of how power, law, and accountability collide, and how difficult it becomes to get a straight answer when the stakes are this high. At the center of this exchange is a simple but deeply uncomfortable question. Are there any real limits to presidential power if immunity applies broadly to official acts? And instead of a clear boundary, what we see again and again is a pattern, deflection to legal tests, references to court opinions, and a consistent refusal to engage the core hypothetical directly. That matters, because the senator isn't asking random, outlandish questions for effect. Each hypothetical is carefully designed to stress test the principle. Assassination, bribery, abuse of military power, arresting political opponents. These aren't predictions, they're pressure points. They're meant to expose whether the legal framework being defended actually holds up under extreme conditions. And the revealing part isn't just what's said, it's what isn't said. At no point do we hear a firm, unequivocal rejection of those scenarios. Instead, the response leans on process. The court would apply a test. It depends on the category of power. I can't prejudge. Legally cautious? Yes. But politically and institutionally, that caution creates a vacuum. Because if the answer isn't clearly no, then the implication becomes harder to ignore. The exchange also exposes a deeper tension between two systems of accountability. legal prosecution, and political impeachment. The argument being probed here suggests that prosecution may depend on impeachment happening first. But then the senator flips that logic. What if impeachment itself is prevented? What if the system designed to check power is neutralized by that same power? That's where the scenario becomes less hypothetical and more structural. Because now the question isn't just about one president. It's about whether the system has a fail-safe at all. And this is why the frustration escalates as the exchange goes on. You can hear it in the repetition, in the narrowing questions, in the insistence on yes or no clarity. The senator is trying to force a line to be drawn. The nominee is trying not to draw one. That gap between demand for clarity and refusal to provide it is the real story here. It leaves viewers with a critical takeaway. Legal frameworks don't just depend on what's written in court opinions. They depend on how clearly their limits are understood and enforced. When those limits become ambiguous, trust in the system starts to erode. Not necessarily because of what has happened, but because of what might be possible. So the real question for you is this.